Hello again. How can I help you today?
I see a lot of people trying things to get out of a contract they signed. They claim that the party to the action is wanting money of exchange based on money of account. I thought you might be able to explain the difference to me as well as explain the legal or lawful way to deal with this issue.
Sure. I see the same thing. What people fail to see is the simple fact that they agreed to something, a contract. Then the people who are doing as you suggest, go into default on a loan, for example. Then they wonder why the bank or mortgage company follows through with a foreclosure or whatever. Is this what you're talking about?
Yes, that is exactly what I am talking about. Or they claim that they are not the uppercase name on a document to which they signed and then they state the contract doesn't apply to them.
Yes, I have seen this before. The truth of the matter is if you sign a document then you are liable to the contract because a fiction or straw man, as it is known, cannot sign anything. If you sign the document you're the legal representative for the name you signed unless you put a qualifier in front of or behind your signature, such as if you signed something on behalf of your employer. We won't get into that in this discussion.
Okay, so if I sign a document or have signed a document for a loan or license then I am liable. But what if I find out later that the contract is not valid, or at least I suspect it is not valid or legal? Then what?
Well, depending on the contract or loan agreement, you would have to remain in honor with the contract or loan so that you do not fall into default. In a home loan, for example, you could be evicted or go into foreclosure for missing 2 payments. Therefore, if you suspect something is not legal or lawful with the contract or loan, you do not want to go into dishonor because then you will be on the defensive for your actions, the defendant in a case, for example. You instead want the other person to be the defendant. Therefore, you would start an action against them in court while remaining in honor.
Could this cause me a problem, seeing as I am in honor and remain in good standing with the bank, for example?
It could. Yes. The bank or mortgage company, for example, may have the right to call the loan and make the total amount payable at any time, and provide you 72 hours to pay the total outstanding balance.
How would I know if this could happen?
Read the loan contract, and if you have any doubt then don't try to challenge the contract, because it's not worth losing your home over.
So if I dishonor the contract and get served with the document, I will have to defend my position. Is that what you're saying?
Yes. However, because you will be in dishonor of a civil contract and you in effect would be challenging the validity of the contract for fraud, you're in the wrong type of court. You would need to be in a different court for the judge to have the authority to deal with your challenge. In some cases, however, you may be able to file a statement of defense and counterclaim.
Well, wouldn't that work to stop the foreclosure or charge against me?
It may prove your point, but you would most likely still be found in dishonor or default for being in breach of the contract regardless of your logic or reasoning behind it.
So if I remain in honor with the terms and conditions of the contract, then they would be the only ones who would then need to defend my claim and I would never be at risk. Is that right?
Basically, yes, so long as you can get them in default and you are able to argue your case. Doing it the other way, you would still be guilty of breach of contract and the judge would have no alternative but to find you guilty.
Okay, I understand. So if I remain in honor of the contract or lease or loan and then start an action against the company for fraud or whatever, then how can they come after me? I therefore can't be guilty of anything and only they can? Right?
Exactly. However, you would be wise to give the company a chance to prove the loan or contract is not based in fraud or deceptive practices. You first need to write out an affidavit and have it sworn, and then a statement of claim. Request a docket number down at the court and put the number on your statement of claim. File one copy of your affidavit and statement of claim with the court and get one served to the party. Typically they have 20 days to reply, and if they don't, you then request a trial date. Serve notice of the trial date to whomever you are taking to court and attend court. If you, however, do not do your paperwork correctly or do not argue your case to convince the justice to see things your way, he or she may award cost to the other side, which means you may get stuck paying the other side's legal costs. You can't bring frivolous cases into court as the courts will not accept this.
Anything else I should know?
Depending on where you live, and if you think the company or whatever is doing something illegal, you always want to try to talk to them before going into court. Court is your last resort in all matters. This is why if you can agree or get the other side in default, you may be able to avoid court or win by default.
What happens if the other side doesn't respond to my paperwork?
He'd file an affidavit and motion for a summary judgment in favor of the plaintiff, which is you. You should win your case by default. But be prepared to argue your case in front of the judge.
So if I follow the steps as you have outlined, then I am never in default, and the other side will need to defend against my position. This sounds like a lot smarter way to do things than going into dishonor.
It is. However, you may also get asked by the justice, why then did you sign the document or contract in the first place? You would then need to be able to explain why you are now after the fact bringing the other party into court.
Right. Why would I sign a contract and then challenge the validity of that contract? That is what you're saying, right?
Yes. Exactly. So your claim might be that the contract was without full disclosure, or that the other party did not give anything of consideration, or the contract is in violation of general accepted accounting practices, or whatever your argument might be. Without knowing the contract to which you are speaking, I am only giving you general information, and how you use or misuse the information is your responsibility.
Understood. So to be clear then, if I am in dishonor for not maintaining payments on a loan or lease or whatever, and I file a statement of defense, I cannot really challenge the validity of the contract.
Correct.
But what if I file a statement of defense and counterclaim?
Well, a statement of defense and counterclaim are the same document, not two separate documents. And again, you may be in the wrong type of court for such a defense, but it may work. You'd be better off to start a separate action where they must defend your claim.
So if I start a separate claim, would that be in a criminal court or civil court?
Depending on where the contract was signed, you may be able to file a criminal action directly into the court. However, in some places you need the police department to do it. This cannot always be an easy task, and you may need to start a civil action against them, which may or may not get remanded over to a criminal court by the judge. You can try laying a criminal information at the police department, and if that fails, then start a civil claim.
The claim that I am not the uppercase name, is that a valid argument?
If you signed the document, then you are liable. Uppercase or lowercase, who cares? The best advice I can give you is read about court procedures until you are comfortable with the procedure, and then attend court a few times to see how things work. You can usually get a friend to help you in court. This person may not address the court unless there are special circumstances, and can only assist you in finding the court or locate papers while you're doing your defense. This person is referred to as a Mackenzie friend. You can also get a friend to act as an agent for any case under $25,000. This value may be different depending on the province.
So you have provided me general information, but it is not legal advice.
Yes, I have provided you general information only. And because each case and scenario is different, you should review the facts in each situation and research the particular statutes and alike before taking action. If you do not feel equipped to deal with your case, then you could ask a friend, or as a last resort, speak to a lawyer.
Before I let you go, what if a lawyer or commissioner of oaths will not swear my affidavit? Then what?
Go find another lawyer, or use the clerk of the court, or head postmaster, or someone at City Hall.
Oh, I was unaware of my other options. If all of that fails, then what?
Explain your case to the justice. The same thing if the attorney won't accept your paperwork. Tell the judge or get a process server to do it, and request an affidavit of service. Always an affidavit of service gets filed after the other party is served with a document.
Every time I serve or have someone served a document, I must file an affidavit of service with the court?
Yes, and if you used a process server, ask them to file the affidavit of service with the court, and give you a copy.
Good to know. Thank you.
No problem. I am here to serve and protect. But remember, review your case and be sure you can back up your claims before you even think of starting an action. One other point to remember is that every statement of defense, or statement of claim, must also include a sworn affidavit.
Write and review court procedure at the library or purchase a book on court procedure.
Right. I have only provided a quick overview. I wish you the best in your adventure.
Thank you.
You're welcome.